Are you or a loved one disabled? Do you feel alone, lost, and confused as to how to win your Social Security case? If you're watching this video, it's probably because you have so many questions and you're desperately looking for the answers. Hi, my name is Avi Libovic, and I'm the owner at Benefits for All and the lead attorney at Avi Libovic and Associates. Over the course of my 20-year career, I've overseen the processing and screening of over 500,000 disability cases, working with the largest hospitals, neighborhood clinics, primary care physicians, and even individuals who had no access to care at all. My strategies for how to win the case have made me one of the top experts in Social Security law in the entire nation. My life and my career were going great. And then one day it all came crashing down. It started first with some abdominal pains. And before I knew it, I'd been admitted to the hospital several times and I required multiple surgeries. I found myself unable to work and disabled and in desperate need of my own benefits. I understand exactly how you feel. I was in your shoes. And I'm going to take you through the process and help you and give you everything that I know so that you can win your case. I'm recovered and I'm back at work. And I have a newfound passion for helping disabled people because I myself have been there too. Call our office today for a free screening and to see how we can help you with your Social Security case. At the same time, enjoy these videos and webinars that we've prepared to you to help you understand how to win your Social Security case. Hello friends, this is Avi Libovic and you're watching another amazing webinar brought to you by Benefits for All, where we teach you how to win your Social Security disability case without having to pay the cost of an expensive attorney. We're standing in Santa Rosa, New Mexico in front of the old historic Guadalupe courthouse. This courthouse has been here since 1905. The history around it, the history around the community, which is a very small community, about 2,700 people, is something that it's very difficult to put into words. You have to come here to see it, to feel it, and to understand what it is to live in Santa Fe, New Mexico. I've said this before and I'll say this again. The way a person lives in New York or in California or Chicago or Atlanta or Dallas or any other big city is dramatically different than some of these smaller towns where the population is 2,700. There's a quaint feeling as you walk down the street. It's almost as if every person knows who you are and everyone knows each other. And again, it seems like a terrific place to raise a family, a terrific place to settle with your family and to support your family and earn a living. And I encourage you all to come here and check it out. Anyways, since we're standing in front of the courthouse, we're gonna make it brief. I wanna talk about a sensitive topic which many people don't like to speak about, but we need to address it. And that has to deal with how do we handle and how do we address any arrests and incarcerations that you may have had prior to this application. Again, how do we deal with any arrests or incarcerations that you may have had prior to this Social Security disability application, either for SSI, Supplemental Security Income, or for SSDI, Social Security Disability Insurance. Let me tell you all a little story, okay? And this is a story that didn't take place once. This is a story that's taken place hundreds of times, if not thousands of times over my career. Whenever I meet someone for the first time, how are you? Nice to meet you. Tell me about yourself. Let's hear what's wrong. Let me tell you about your medical conditions. Fine. We go through a basic, we call it a screening, right? We want personal information and background. We need to confirm citizenship, residency. We need to confirm if the person has income or resources and what the medical condition is. There's a lot of different things that we have to confirm to determine whether or not we have a good case. But then we come down to a question, right, that many of you all of a sudden start to squirm in your seat about. A question that many of you don't want to answer, and you even get sometimes hostile with me when I ask that question. The question at the end of the interview is, I know that this is difficult to answer, and it may not even apply to you, but I need to know, have you previously been arrested? If so, when were you arrested? What happened? Did you go to court? Were you incarcerated? If so, for how long? Now, I have trained my staff to always ask that question at the end of every screening. And many times, some people just say, no, I've never been arrested. Other times people say, yeah, I've been arrested and this is what it was for and these were the circumstances. But other times, all of a sudden you get very hostile on the phone. What do you need to know that for? That's none of your business. I don't need to tell you anything. Well, let me tell you something. Again, I have nothing up my sleeves. I'm only here for one reason, and that is to help you. I'm giving you the experience of over 100,000 cases, right? And I'm putting it all on the table for you to understand and to pick up and to study and to learn and to help you. So I have nothing to gain here. But when I ask my clients if they've been arrested, what I'm really asking is I need to understand the credibility of the witness. Because at some point, you, the claimant, hopefully you'll win an application. If you don't win an application, hopefully you'll win a reconsideration. But if not, you're going to end up before an administrative law judge. And I have to tell you, there's no way around it, and I can't sugarcoat it. If you've been arrested before, and if you've spent time in jail before, for whatever different reason, right or wrong, the judge has now viewed you as potentially not being credible. What does that mean? That means if you were arrested for, I'm just going to pick some, random crimes, possession of drugs, distribution or selling of narcotics, drugs, burglary, robbery, right? Any other type of felony crime which often involves some type of firearm or some type of weapon that could result in bodily injury. Okay, if you've gotten in trouble for that, right or wrong, whether you did it, whether you didn't do it, whether you're your friend, whether you're in the wrong place at the wrong time, the judge doesn't care. And you know what? When you start talking about your medical condition, unfortunately, the judge looks at you as a liar. He looks at you as someone who he or she cannot trust. So now we have a dilemma as we stand in front of this courthouse here in Santa Rosa, New Mexico. How do you go into your hearing and present testimony about your medical condition and about the pain that you're in and why you can't work, right? When the judge is going to look at you and he's going to say, I don't believe this person because they were in jail. And someone who's been in jail and someone who has a record is clearly not trustworthy, right? Obviously they're breaking the law, they're not trustworthy. So if I couldn't trust you then, I couldn't trust you now. And I'm not going to listen to your testimony. And you say to yourself, wait, that's not fair, I did my time. And the answer is, I know you did your time, but it really doesn't matter. The judges don't care. So here's how I get around it. And I find that it's been very, very helpful and it's been very, very successful. As the attorney, I try to make an opening statement. Not every judge will let me make an opening statement, but I'm usually pretty aggressive and I really say to the judge, Your Honor, it's important to me, please, I'd like to make an opening statement. Even if the judge says, I want to ask some questions first, and then after some questions are done, you can go ahead and you can say what you want to say. So fine, I let that judge ask their questions, but then when it's my turn, what I do like this is I don't beat around the bush. I don't play games, I don't pretend that it didn't happen. I stand up, I take ownership for it, of my client, of what they did. I address it straight on, and I resolve it, and I diffuse it. What does that mean? Your Honor, right, this is like an opening statement. I'm here today to apply for disability benefits because I have a medical condition of whatever, cancer or seizures or, whatever's wrong with me, congenital heart, problems or whatever it is. Now, Your Honor, before I go into the testimony and before I go ahead and ask a series of questions, I understand that you're going to have some credibility issues on me or on my client because what? Because there's a previous arrest. And not only is it a previous arrest, there's a previous incarceration. So I want to go ahead and I want to address that head on, Your Honor. Yes, this is what happened so-and-so, and this years ago. The court found the person guilty, and I take ownership for that. I was at a difficult time in my life. I was on my own, and I made a lot of mistakes. But since that time, Your Honor, I've worked very hard to change my place in society, to change myself as a person, and to go ahead and to become an upstanding community member. I may not be able to do as much as I want because I'm not feeling well, but you know what, Your Honor? I haven't committed any crimes in X amount of time. I'm not engaged in any drugs or alcohol, right? Your Honor, I want to tell you the truth. I've now gone ahead and I reestablished my relationship with my family. Before, my family didn't want to hang out with me because, I was involved in some dangerous things with some dangerous people. They didn't want to hang out with me, but you know what, Your Honor? I've changed. I'm a changed person, and I started to hang out with them. And Your Honor, not only that, I started to attend church. Whatever it is that you need to say, it should be the truth. No one's telling you to lie. But you don't want to pretend that it didn't happen. Because if you pretend that it didn't happen and you don't have a conversation about it, the judge is automatically going to take that information without having a chance to discuss it with you, and the judge is going to use that information against you. I know it's not fair, And I know that if he or she would write it in the decision, well, because so-and-so was arrested, I cannot, consider them credible, you may have an appealable issue over there, but you don't want to go to 2 years appeals counsel. You want this thing to get paid, you want it to get approved, you want to move forward with your life. So therefore, my recommendation to all of you who've previously been arrested, right, and who may have spent time in jail, if you've been arrested, and the case was dismissed, you didn't go to jail, or you got probation, then it's very simple. It's the same story. You just tell Your Honor, this is what happened, and it was dismissed in probation, and I haven't done anything since that time. But if you did spend time in jail, you just very casually, right, in an apologetic way, but also taking ownership of it. Your Honor, I was a different person back then. I was young, I was silly, I was stupid, I was down on my luck, I made mistakes, I'm a changed person. When did I change? I changed in jail because I realized when I was there that I had hit rock bottom. I realized that I was there, that my life was falling apart, and I never wanted to be in this situation again. And you know what? From that day forward, Your Honor, I've never stolen, I've never lied, I've never cheated, I've never been dishonest. And with that being said, Your Honor, unless you have any questions for me, I just want to let you know that we're going to move forward with my testimony, and I hope, please, that you'll be able to match up what I'm saying together with what is in the medical records so that you can have a more complete story, so that you can add color to the picture that's already being drawn. Please, Your Honor, don't let any previous episodes in my life or any mistakes I made in my life impact my decision, your decision today, or my testimony today, because I need you, please, to look at the medical records and listen to me and understand. And with that, right, you move forward. I'll add it over here now, and I'm going to add it in another webinar, which is the same technique is used with drug and alcohol usage, right? Previous drug and alcohol usage. If you're filing a claim for benefits and all of your medical records you have alcohol and lab results that shows drugs, right? Whatever the drug is, it doesn't matter, any drug, you have a problem. Don't think the judge didn't see those lab reports in your medical records. The judge saw them. The judge knows that you were doing drugs or alcohol. It's all over your records. And for the most part, you're coming into that hearing about to give testimony with a really big roadblock ahead of you. So this is how I get around that same type of issue. I do the exact same thing for my clients. But I do a little bit more, actually. I take ownership for what happened. I'm going to give you an example in a minute. But prior to that, I go ahead and what do? I start sending my clients months before to an AA meetings or NA meetings. And I send them attendance logs. And they get the logs signed every time they go by the person who's running the meeting in the group. And not only that, if necessary, I go ahead and I encourage them to go to inpatient facility. If possible, I encourage them to get some sobriety chips for 30-day sobriety, 60-day sobriety, 90-day sobriety, whatever it is. If they go to an inpatient program or an outpatient program, if I get a certificate that says that you've graduated, then you're golden. Because what happens now is you've taken a really bad situation, which is you and medical records filled with drugs and alcohol, which basically demolish your case, and you've stood up in court and you say, Your Honor, before I move forward with my testimony, I just want to address head on, so you can ask me any questions before we get anything else, that I'm aware that on several years ago in the older medical records, there may have been some labs which have shown some drug or alcohol, positive testings and indications for drug or alcohol. Your Honor, I am happy to say that I've been sober for whatever, 30 days, 60 days, 90 days, 6 months. Here's my sobriety chip. Your Honor, here is my attendance logs for the AA or the NA. Your Honor, here's the phone number for my sponsor. You can call him and you can confirm that I check in every single night. Your Honor, I am happy to say that again, my life was a mess. I've cleaned myself up. I have a terrific family and friend support system and support team and a sponsor, and I'm drug-free for X amount of time and alcohol-free for X amount of time, and I feel great. Period. Keep your mouth shut. Once that is said, you let the judge look at the attendance logs from the AA or from the NA. You let the judge look at the sobriety chips or the certificate of completion of the rehab program or the inpatient program or the outpatient program. You let him offer him again if he wants to call your sponsor, if you need to get a letter from your sponsor to show that you're doing what you need to do, or maybe perhaps if you have a relationship with the clinical director of whatever rehab program you were doing, if you want to get a letter saying that you've been clean and you've been participating and that you're doing terrific, you do that, then you know what you've done? You have diffused, you have disarmed the bomb of your case. Whereas before, the bomb of your case was either the arrest or the incarceration or the drugs and the alcohol. You've diffused it, it's gone. I mean, it's still there. But you didn't pretend like it didn't happen. It happened, the judge knows it, you know it, and it's out on the table and it's discussed. And if the judge has any more questions, he or she will ask you. Now, when I've made that type of speech before, especially for the drugs and alcohol, in most cases, the judge will look at the claimant and he'll say to me, Mr. Leibovic, thank you very much. And he'll say, Mr. Claimant, let's just call him Joe Schmo, Mr. Schmo, I applaud you for your courage and for your strength for cleaning up your life. Thank you very much for being honest and telling me what your story was. Let's now move forward. I've never had a judge say to me, you know what? Even with the sobriety chips and even with the attendance logs and even with the certificates, I still don't believe you. It's never happened. It's never happened. Every time you've been able to show exactly what I told you, attendance sheets, certification, sobriety, logs, whatever it is, it's diffused and it's disarmed and it's done. The issue with the judge and the credibility, done. If you can get a letter from a pastor or a rabbi or a priest or someone, maybe another attorney or someone who you know who's an upstanding citizen, someone who's involved in government, to say that they know you for X amount of time and they're aware of your circumstances, that you had a rough early childhood or earlier years, but now you're a changed person, that's a letter of support. It helps. Does it have anything to do with your medical condition? Nothing at all. Nothing to do with the medical condition. Are you guaranteed to win your case? You're not guaranteed to win your case because it all comes down to your medical conditions. But you have diffused the bomb in the case. The elephant in the room that no one wanted to talk about, which was your past drugs or your past alcohol, your past arrest, you've talked about the elephant, it's there, it's finished, and you've successfully disarmed it. With that in mind, I remind everyone again, you can do this, you can represent yourself, and you're going to do great. I'm teaching you, as you see, everything that you need to do, everything that I know, everything, all the arrows in my quiver, all the weapons in my arsenal, I'm giving them to you. I'm giving them to you. I'm going to tell you, and they work. I know they work because I've used them. And I've trained, I had more than 20 attorneys working for me. They used them, and they worked. If you listen to these webinars, if you don't get nervous, if you break it down piece by piece, you will find that you can do this, provided that you're feeling well enough to do it. You know, so if you're not feeling well enough to do it, obviously that's a problem, but you will be able to do this, okay? Watch the webinars, learn them, study them. You don't have to memorize them. Have a familiarity with the process. Application, recon, hearing, right? Have a familiarity with the forms. The authorized representative form, 1696, the 827, the authorized to release medical records form, right? The 3441, the disability, whatever the form you need. Have a familiarity with the forms, and then have a familiarity with what? With timelines. I need to get this in within 60 days. I need to appeal this within 60 days, right? You're gonna be great. If you have any questions, you watch the webinar. If you've subscribed, you can download them. If you need to purchase one, then purchase one. Download it. You're gonna do terrific. I wanna help you. If our office can help you, if you feel that you've started and maybe you can't finish it on your own, give us a call. We'll give you a free screening. And you never know, we might be able to come down there and try to help you out wherever you're located within the country. My name is Avi Leibovic. I encourage you again, tell your friends, tell the people who need it, www and benefits for all. We are going to teach you how to win your Social Security case without having to pay the expensive costs of an attorney, okay? It's my agreement with you. It's my pledge to you. I will teach you everything, okay? You're going to do terrific. I know you can do it. I hope you feel well. Again, my name is Avi Leibovic, and I look forward to speaking with you soon. Thank you very much.